really hope that you and your loved ones are keeping well during our current challenges. But obviously there are other things happening in the world and other important developments in different aspects of health in our lives. So today I'm very grateful to be joined by Vivienne Byrne and David Murphy from the Data Protection Commission, and they're specifically from the health and voluntary sector of the DPC. And I suppose by way of background, like many other protections we enjoy, the mechanics of data privacy and protection are perhaps not the most exciting generally of topics for a dreary Tuesday afternoon. That is until something goes wrong. And someone recently said that data has now emerged as the most valuable commodity for each and every one of us. And I think in particular, health information is crucial to all aspects of research, which we obviously have an interest in, but it's also important to each of us individually. And it's incredibly valuable to outside groups. I mean, I think we're seeing a lot around how social media and that are using data, but also I think we need to know more about the context of how research uses data and the protections that are afforded to us. So I think like anything of value, we need to be able to protect it. So today, Vivienne and David will briefly outline the workings of the data protection in protecting specifically our health data and some very recent changes in the legislation that underpins those protections. A few housekeeping notes before we kick off. Vivienne and David will talk to us for maybe 20, 25 minutes or so. And then we'll have some time to answer questions as best we can. We would ask to say that everybody remains muted to avoid the barking dog and the cat, etc. in the background. So please feel free to put your questions into the chat box as we go along, and we can then go through those at the very end. And we'll have a couple of polls as we go through too. And also we're going to record the speaking part of this, or the talk part of it. We won't record the questions, just in case anybody wants to catch up with it afterwards. So thanks again for coming along. And without further ado, I'll pass over to Vivienne and David. And David and Vivienne, when you're ready, just give me the shout and we will put the first of the polls on there.
Great stuff. Thanks a million, Rob, and thanks to everyone for joining us this afternoon. This is the first engagement that DPC has had with a charitable body. We're delighted to collaborate with the Irish Cancer Society on this outreach activity to really get out and speak to people about understanding the specific application of data protection law and their rights in the healthcare context. And we'll speak a little bit more about this when we talk about the functions of the DPC. But what we want to get out of today, I suppose, is to have a kind of a brief run through, an understanding of the principles of data protection, and how in particular they apply to the healthcare context. We'll have a look at how individuals' data protection rights can be exercised in the context of healthcare, and then we'll have a look at health research, because that's as Rob mentioned, kind of the hot topic at the moment, and that's where the legislative changes are. One of the big values for us in conducting this webinar this afternoon is to figure out and to learn from you, the participants, from people who engage with the health sector and have concerns about data protection, what your concerns really are and what questions need to be answered. And this will actually help us to frame published guidance as we go forwards and will inform our thinking. So because of that, we've set some questions to start off, to sort of gauge where people think their knowledge is, and we'll ask a follow-up question at the end to see what people think they've learned, and that will help us know what comes next. So what I might do, Rob, is ask you to put up the first poll. So this is at the outset of our event today, to really ask you, are you confident that you understand the role data protection plays in your care and treatment? And that's what we hope to answer. So we'll just give that a few more seconds for people to have a read and to let their answers filter through. As I say, this is really interesting for us because sitting in the DPC, well, sitting at home as we all are now, but in the virtual DPC, it can be a little bit academic in figuring out how to apply data protection law and how to deal with all the things that we have to do. But you, the public, are the stakeholders, and it's absolutely vital that we get out and talk to people and learn what are people's concerns, and really, do people feel that they're knowledgeable enough and comfortable enough to exercise their own rights in the variety of interactions that they have in the healthcare sector, and indeed in other sectors. Okay, we might call the poll to a close at this stage, and let's see if we can share some slides. This is where Murphy's Law is going to kick in and prevent anything from working properly. Let's have a look. Okay, so hopefully you can see your slides, and we shall crack on. So as I say, today's session is entitled GDPR for People Impacted by Cancer. This is our engagement with the Irish Cancer Society, but what we're talking about today is generally applicable to the understanding of people's interaction with data protection and data processing in the healthcare sector. My name is David Murphy. I'm the Assistant Commissioner for Consultation with the Health and Voluntary Sectors at the DPC, and I'm joined by Vivienne Byrne, who is the Lead Consultation Specialist on the Health team and Voluntary Sector team. So hopefully we'll be able to bring some expertise and knowledge to the session today. But as I say, we're here to learn from you as well. Before we get into the details, so I'd just like to give a little rundown of what we're talking about when we talk about data protection legislation and what the data protection legislative frameworks are. So of course we're talking about the General Data Protection Regulation, the GDPR, that came in 2016, was announced and is now in effect since 25th of May 2018. It is a regulation, so it has a direct effect across the European Union, and was largely brought in to meet the modern challenges of big data, but also to harmonise across the EU the understanding and the application of the principles of data protection. But of course, the GDPR isn't the only game in town. We're also looking at the Data Protection Act of 2018, which came into Irish law at the same time as the GDPR. It brings in, for example, certain derogations that member states are allowed to make to the GDPR, several in the area of health, also noticeably in the area of the consent for children to electronic communications engagement. It's also established the Data Protection Commission, which was previously called the Office of the Data Protection Commissioner. So the DPC was established under the Act, and that's where we get our powers to actually carry out our supervisory tasks under the GDPR. The Data Protection Act 2018 gives very, very wide scope for further regulations to be made by a variety of ministers, the Minister for Justice in particular, but other ministers as applicable. And we've seen a number of statutory instruments come through to give effect to particular rules and regulations in data processing. Of particular interest today, of course, are the health research regulations, which came out a couple of months after the Act itself in 2018, and set out the specific rules around the safeguards for processing personal data in health research. But as I say, we'll go into that in a good bit more detail later on. So we'd like to speak a little bit about the role of the Data Protection Commission. I might start off with talking about our enforcement side, and then I'll ask Vivienne to come in on the engagement piece, which is our consultation side. But really, what you'll see most of kind of in the news, well, hopefully, is around the enforcement end of things, the statutory powers of the DPC to investigate and to apply the corrective measures that are provided to us in the GDPR. What this really comes down to, and what we have to hold at the forefront of our minds, is that the primary role of the DPC is to uphold the data protection rights of individuals. Those rights are enshrined in European law and come from the European Charter of Fundamental Rights under Article 7 and 8, and they are. That's as serious as it gets, really, and that's the point that we have to keep bringing home to data controllers and to other organisations, that these are fundamental rights. The data protection isn't something that can be brushed to one side or just viewed as a tick box exercise. There was a lot of talk when the GDPR came in about the fines that can be issued. And you may have seen recently, for example, the decision involving the issuing of a fine to Twitter. What I would say is that when supervisory authorities such as the DPC under the GDPR exercise their corrective measures and powers, we are commanded to be effective, dissuasive, but also proportionate in how we act. And the imposition of a fine really is at the end of our regulatory powers. We have a number of other corrective measures, such as the issuing of enforcement notices, of corrective notices to instruct bodies to cease processing personal data until they've brought their processing operations into line. And really, the ultimate sanction then is the administrative fine. But that's kind of at the end of a range of corrective measures that we must consider when we look at enforcement. So I might bring Vivienne in now to talk about the other side of the house where we sit in terms of engagement, outreach and consultation.
Thanks, David. Just good afternoon to everybody. And just with regard to Rob's earlier comment about the cat, I have to warn you, I may not be able to prevent my own from making an appearance. She seems to like to do it when I'm on a Zoom meeting. So yeah, as David mentioned to you, there are in essence, two arms of the DPC. Our arm in the consultation unit is very much the smaller arm of the organization, but we like to think of ourselves as being quite active, particularly in the health sphere, since the unit was actually just introduced in 2019. So the function of consultation, it falls under Article 57 of the GDPR, in that the Data Protection Commission has an outreach function to perform. It's one of our statutory obligations. And the idea behind this in terms of regulation is if we can have an engagement with data controllers when they're starting to design projects or when they're introducing legislation or regulation, statutory instruments, that's a really good opportunity for data controllers to get things right, to have this whole notion of data protection by design and default embedded into projects. So while a lot of our work is dealing with data controllers, at the end of the day, the ultimate stakeholder for us is the data subject. So that's always what we have our eye onto. And we're both delighted, as David mentioned earlier, to be able to talk to you today directly. It's something that we don't get the chance to do often enough in an official capacity. Unofficially, we're often talking to people about their own particular views on things. So this is great. It's really something we look forward to doing more in the future. So in terms of our engagement, what do we do? Well, as I mentioned already, we will talk to data controllers prior to the beginning of processing and when they're at, hopefully when they're at the project design phase, and we'll give them a good steer. While our recommendations aren't, we don't give like a rubber stamp and say, yes, if you do this, you'll be in compliance. We can offer what we call a good steer to data controllers. And very often the feedback is when we say things like, you may wish to consider data control, X activity or X form of processing, data controllers really sit up and notice. We kind of characterize ourselves as we're like the carrot end of the house, whereas our colleagues in enforcement are like the stick. So if we can get it right at our end, it means less enforcement activity and ultimately less problems for the data subjects, less rights not being upheld. So I'll just hand over to David then maybe for the next slide.
Yeah, great stuff. And I suppose, again, in terms of engagement, we also work with representative bodies in the health sector. We've worked with the ICGP, for example, on developing guidance and to help them to understand how to apply data protection principles in their own area. So speaking of principles, we'd like to just do a quick run through what the principles of data protection are. So data protection law is what's called a principles-based area of legislation. It's technology neutral in that it doesn't specify particular conditions for particular industries or particular technologies. What it does is set out a series of broad principles, and it's then the responsibility of the organization that wants to process data to make sure that they apply these principles in action. So we might just run through these and then think about how they might particularly apply in the context of healthcare. The first principle is that the processing of personal data must be lawful, fair, and transparent. When we talk about lawful, so it's required to identify an appropriate legal basis to process personal data, and the GDPR offers a few, one of which is the consent, obviously, of the individual, but that's not necessarily always going to be the case, and it certainly shouldn't be thought that consent is always the best. It's the responsibility of the controller to identify the most appropriate, and this may, for example, be in relation to processing may be required to carry out a contract in a financial area. Public bodies can process personal data where it's necessary to achieve their tasks in the public interest, and private bodies can process personal data to carry out their own, or to meet their own legitimate interests, as long as they don't infringe upon the rights of individuals. And there are some other legal bases, but we'll talk about that a little bit later, and particularly around consent. The principle of purpose limitation means that personal data, when it's obtained, should only be processed for specific and legitimate purposes. So it's not expected that people will collect data and then use it for other things that occur to them later on down the line. And I think that's particularly important in healthcare, where people are entrusting doctors, hospitals, and so forth with their sensitive personal data, that they understand that it's only going to be used in their own care and treatment, or possibly for a secondary purpose involving research, but that this is set out at the outset, and something else isn't going to happen later on that you're not aware of. I suppose to step back to the first principle for a moment, again, when we think about healthcare, that principle of fairness, I think ties in quite well in the healthcare setting when we think about medical ethics. Medicine is the practice of medicine is a well-regulated area, and I think it kind of has baked into it that ethical principle that relates to fairness in the GDPR, and that's something that we see echoed in the professional requirements of medical practitioners, through their own regulatory bodies, the Irish Medical Organisation, and so forth. And transparency, of course, it requires the provision of sufficient information to individuals to understand what's actually happening with their personal data that they hand over. Moving on to what we call data minimization. So this is a broad principle, and the message that it sets out is simply that you should only ever process the minimum amount of data that you actually need to achieve your purpose, and to avoid collecting excessive data or data that's essentially irrelevant to what it is that you're trying to do. Again, this is important in the healthcare setting, in that excessive records are not built up, and that in care and treatment only the necessary data is undergoing processing at any given time. The fourth principle refers to accuracy, and it requires organizations to keep data accurate and up to date where possible. And I think it's very clear the importance of the application of this principle in the provision of healthcare. Maintaining inaccurate data presents very, very clear risks to patients in terms of their care and treatment. It also, when I speak to medical practitioners and to doctors, nurses, and so forth, they have a very clear understanding of the risk posed to themselves in terms of medical negligence through the lack of accurate records. So really, this is an extremely important principle from both sides of the equation, from the practitioners and the patients. Storage limitation refers to the principles. It's a principle of data retention, and again, it's a simple principle, but that needs to be applied quite carefully by organizations. So the rule behind this principle is that you should only retain personal data for as long as you need it to achieve your purpose. The GDPR, again, does not set out time limits. It's up to the individual controller to figure out what that is. But the message really there is that you shouldn't be holding on to data for an unnecessarily long period. And once the purpose has been reached, you should delete or securely destroy the data. Now, in the context of healthcare, obviously a person's medical record travels with them for the course of their life. But when people move from one practitioner to another, it's important that doctors review their data retention schedules and make sure that they're not holding on to data that they don't need anymore. Good examples of this are the HSE's data retention policy, which sets out a wide framework of time periods that have been identified as relevant for the retention and storage of certain records. And then finally, we come to the requirement to maintain the integrity and confidentiality of personal data. And this is really when we're talking about the use of security systems, and this is becoming more and more important as we see a widespread move towards e-health, towards the practice of telemedicine, and the development of things like the electronic health record. Much more of which we're going to see coming down the line as the HSE, the Department of Health, move forward with implementing the Sláinte Care programme and all the endeavours of eHealth Ireland. And it's again very clear why this is fundamentally important in the provision of healthcare. You're talking about very sensitive data in many cases, very personal data, dealing with personally sensitive matters of patients. And this is something that we're very conscious of when we speak to people in the health sector, that and indeed that's largely the reason that this separate team was developed in the DPC, was that we recognize the importance to patients of trusting that their personal data is being held in a secure manner, is being accessed properly, and that proper governance procedures are in place when they engage with the healthcare practitioner, with the hospital, with the GP, so on and so forth. It's very important to people in this part of their lives. So we mentioned that we would come back to consent, which is one of the possible legal bases for the processing of personal data, but in the context of healthcare is usually not the most appropriate. But there's a few issues to maybe talk through around that. And when you engage with a healthcare practitioner, there's a number of different consents possibly going on. It's important to remember that consent to receive medical treatment and to undergo a medical procedure is of course required, but that's nothing to do with data protection or data processing. When we talk about data processing, what we're really talking about is the personal data that your doctor, the healthcare provider, needs to process in order to carry out their other functions. So the consent to undergo the treatment is quite different from a consent to process personal data. In fact, the GDPR sets out a separate legal basis and separate conditions to allow the processing of personal data for the provision of healthcare, for the diagnosis of medical conditions, for the management of healthcare systems, and so on and so forth. And all of that hinges upon the controller, the person processing the data, being a healthcare practitioner, subject to all the requirements of confidentiality that come with that, or working on behalf of a healthcare practitioner. So, for example, staff in a GP clinic. So in fact, what the GDPR offers is a much more secure and governed route to the processing of personal data than consent might in fact give, were that to be relied on. We note that under the GDPR, controllers have to comply with the GDPR, but they also have to be able to demonstrate their compliance. So if there is the use of consent, for example, consent for participation in research, they must be able to demonstrate that, and they must record it properly. And when we talk about processing special category data, so your health data, the requirement is for explicit consent, which is a somewhat nebulous term, but we kind of talk about it as being a recorded and specific consent. Now, one thing that I would mention here is that we're often asked, does consent require a signature? That's not the case. It is possible to give an electronic consent. It's possible to give consent over the phone or by other means, as long as the controller, the person taking the consent, is in a position to demonstrate that they have provided all the necessary information and that they have recorded the giving of consent accurately. And this is something that's going to become much more relevant, as I say, moving forward in telemedicine, in the provision of electronic health and everything else. So to sum up on consent, explicit consent is not required as a legal basis under the GDPR Article 6 and 9. to process the personal data around health, but, and we'll come to health research in a moment, it is legally required as a safeguard under the health research regulations. Okay, we'll continue on, if this works. So data subject rights, this is something that we want to spend a few minutes on, as a particular focus on what the rights are that the individual has and how do they apply in healthcare. There are a number of rights provided by the GDPR. I've really just highlighted three that we'd like to focus on, rather than going into everything, because I think they are the ones that apply most particularly in healthcare. But if there's anything else that people would like to discuss in the Q&A, we can absolutely come back to that. The first right that really kicks things off is the right to transparent information under Articles 12, 13 and 14 of the GDPR. Because if you don't know what's happening with your personal data, you're not in a position to exercise your other rights. So those articles of the GDPR set out the information that controllers must provide before they collect and process your personal data, so that you understand what's going on. And this is usually achieved through privacy notices, through privacy statements, and in the context of healthcare, through patient information leaflets. So if you're expecting to undergo a procedure in hospital, or if you're enrolling in a study, you should be provided with the necessary information to understand what's happening with your personal data. Following on from the right to information, the next and I suppose very important right that we'd like to discuss is the right of access. So this is essentially a universal right, in that the exemptions to it are very limited, and it's the right to make what's called a subject access request to any organization that processes your personal data, and to be given access to and a copy of any of your personal data undergoing processing. So in the context of healthcare, that includes your entire medical record, it includes notes that may be made on the file, and so on and so forth. And this, when we say that this is an absolute right, it's not for anybody to tell you that to question the reason why you're looking for this, to stand in the way. A controller is obliged to comply with this, and if you're not satisfied with the information that you've received, or if you're not satisfied that they are applying any of the exemptions correctly, you have, of course, the right to make a complaint to the Data Protection Commission, and we will investigate the matter. Now, what we advise in the context of healthcare is that it's very often helpful, if a doctor receives a subject access request, for them to have a conversation with the patient and try to find out, is there something in particular that you're looking for? Is there a part of your healthcare or treatment that you're particularly concerned about and that you want to discuss? Rather than simply handing over the entire record to somebody who doesn't really understand what they're looking at. So I think we think certainly a process of dialogue is very useful and important there, and it should be conducted in a properly engaged manner. There may, in very limited circumstances, be reasons why a doctor feels they need to withhold portions of somebody's medical record. This can occur where they make a consideration that revealing something in the record could in fact harm the mental or physical health of the individual. But as I say, that's a limited exemption and must be applied on the basis of very careful professional consideration by the practitioner. There may be other limitations that can be applied to the right of access. For example, the personal data of third parties can be withheld or redacted, where it is considered that to release it would have a detrimental effect upon that third party. And there can be occasions where a controller has the right to withhold information that consists of opinions about the individual concerned that were given under confidence or under the understanding of confidence. But again, these have to be applied on a case-by-case basis and after careful consideration. So really the right of access is almost universal and needs to be taken very seriously. And the third right I'd like to speak to this afternoon is what's called the right to erasure, or very often it's called the right to be forgotten in the context of the internet. This is a limited right in terms of its applicability. It only applies in certain cases and certainly isn't universal. But it was the cause of a lot of confusion when the GDPR came in, particularly in the context of healthcare. So a data controller is only obliged to facilitate this right where there is no other, where they can't identify an appropriate legal basis to continue to process personal data, or where an individual has withdrawn consent, but where consent was the original legal basis. So for example, when this comes to a medical record, it simply isn't the case that a doctor is obliged to delete or erase a patient's medical record. They are required to keep that. They have an ongoing legal basis to do that, and they need to be able to demonstrate and comply with their own professional regulations. So the right to erasure, again, is limited to certain circumstances. What can come into play there is there is a right where you contest what's held in a record held by a controller to add a supplementary statement. Sometimes that can be an applicable solution, to have a note put on a file to say that you don't agree with the assessment that the controller made, or something that's written down. But again, any of these engagements should take place in a dialogue between the parties involved, and that's what we would strongly advise anyone in the health sector to do. But I think that we might dive into that a little bit more in the Q&A. When we talk about personal data breaches, so this is something that you'll see a lot, probably in the media, and I do have to say that unfortunately the health sector is one of the biggest offenders when it comes to personal data breaches. So a personal data breach, technically speaking, so it's not simply an infringement of rights or a breach of the law. What we're talking about when we talk about breaches is a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. So that's quite a mouthful, but essentially what it means is where a controller essentially allows personal data to fall out of their control, either accidentally or through the efforts of a malign individual in their practice. Hopefully that doesn't happen too often, but it's a significant risk in the health sector. We've all seen the reports of files turning up in the hospital car park and that kind of thing. And as I mentioned at the start, when we're talking about patient data, this can be particularly sensitive and lead to a lot of distress. So it's something that we really are trying to clamp down on and get the health sector to get their act together on this. There are 2 notification requirements around a personal data breach, and they are based upon risk assessment. So in the first case, the controller must notify the DPC within 72 hours of becoming aware that the data has become breached, unless they can make an assessment that there is no risk to the individuals concerned. So that's a very, very high threshold that they must meet. And in most cases, certainly in the health sector, they will be required to notify the breach to ourselves. The secondary notification then is to the affected individuals. And this is, I suppose, a slightly lower threshold on the risk assessment, but they need to see what that risk is to the individuals, and then decide if they need to advise individuals that they may need to take efforts themselves, or simply to make them aware that their data has been lost and is out there in the open. And when we talk to people in the health sector, this is particularly important, because the last thing people want to find out is that their personal records, what they thought was being handled in a very sensitive and confidential manner, is now out there in the ether somewhere. So it's something that we advise to be handled in a very sensitive manner by healthcare practitioners when they fear that they may have lost personal data.
So if I could just interrupt you there for a second, David.
Yes, go ahead, Vivienne.
We're going to put up the second of the 3 polls today. I think Rob or Shauna are going to put it up on screen now. And you can see there, what are your greatest concerns? This is what we're interested in, about the use of your personal data in your care and treatment. So the first option is, how secure is my data? The second is, can doctors access my data when they need to? The third option there is, can my data be used for research without my consent? And the fourth is, can I find out what happens to my data? And the final one, are there any other concerns? So again, it's a nice open-ended question. So if you have any other concerns about the use of your personal data in your care and treatment, just maybe put it into the chat box and we can address it then during the Q&A. And this, we'll also use the information and the way you vote on this. Again, as David mentioned earlier, we'll be publishing more guidance over the coming months on our website, that's dataprotection.ie, around health research, around data protection in terms of healthcare provision. So we'll use the answers that you have today will help to guide us in producing our guidance, and will give us a good idea on what are the big issues for individuals. Okay, so we're almost there. I think we've got about 2/3 of people have voted. So if you'd like to maybe run through those options again and give us a bit of a dig out in focusing our work so that you can get the best benefit out of it, that'd be great. I think we're almost there. Yeah, we're up to 80%. Wow, this is a really good group today. I can see you're highly motivated. I mean, just from a personal point of view, and I know this is something David and I talk about, one of the great things about working in the health sector is that we all use this. We all use the health sector. We're all impacted by data protection issues in healthcare. Okay, I think that's the end of the poll at the moment. So I think we can go back now to the presentation.
Okay, very good. So as I mentioned at the start, what we'd like to just talk about now for a few minutes is health research and data protection, and then we can move into the Q&A. I hope everyone can see the slides. Nothing's gone wrong. So I'd like to talk a little bit about the role of the health research regulations of 2018. The health research regulations, and to give them their full name, you'll see there on the side, the Data Protection Act, Section 36(2), Health Research Regulations 2018. Again, a bit of a mouthful, and we normally just talk about the health research regulations. But it's important to note that these are regulations under Section 36 of the Act. And what Section 36 talks about is the specific safeguards for processing. So it allows a minister to set out what they are setting down as the required safeguards in order to process this in a certain context. And in this area, the Minister for Health has set out in the regulations what are required as safeguards when processing data for health research. It sets out a number of things, but in particular, what's been of most interest and most discussion is the requirement for explicit consent. And we'll come to that in a moment when I talk about the amendments and all the discussion that's taken place since 2018 on explicit consent in health research. It's important to note, and this is something that we talk about with health research practitioners, that the health research regulations are not they're not the rule book for health research. They're not the be all and end all. In fact, they simply sit as part of a regulatory suite for health researchers, among a number of other things. For example, ethical considerations. There are other regulatory measures such as the clinical trials regulations, medical device regulations, which have particular rules around research and testing. And then, of course, everything is backed up by the professional standards for healthcare practitioners set out by their own governing bodies. So when we talk about the health research regulations, it's important to remember that these are just the regulations for processing personal data. They are not the full set of rules for conducting health research. The explicit consent requirement. And again, it's important to note that we at the DPC are a regulatory body. We do not make the legislation and we don't set policy. But our understanding is that the Department of Health's policy in bringing forward the explicit requirement in the regulations was to build into the data protection law the long-standing requirement for informed consent in the conduct of health research. And this goes back to international instruments and international policies, such as the Declaration of Helsinki, that Ireland is signed up to at an international level. And a lot of this comes from the historical reality that we've seen from the early 20th century leading up to the horrifying experiments conducted by Nazi physicians in World War II in Germany. The requirement to to have consent of an individual to have research carried out upon them or with their data. One of the other things I'd like to mention in relation to consent, so when the regulations came out, they had a built-in, I suppose, exemption for consent already, which required an application to a new body called the Health Research Consent Declaration Committee. So this was a new initiative set up by the Department of Health at the time. The HRCDC is an independent body which is able to make a decision as to whether the conduct of research is justified in the public interest and whether the public interest in carrying out the research justifies providing an exemption to the explicit consent requirement. But if we move on to the very recently made amendments, and if anyone wants more detail on these, the Department of Health website would be the place to go. But we'll just have a little chat about them now, because the Data Protection Commission was involved. We were consulted of course, in the making of the original regulations and then in the making of these amendments, as is required in law. So I'm just looking at the amendments in relation to consent. There are some other amendments that are more sort of, I suppose, administrative in terms of how the regulations apply. So when we look at the three areas in which consent is now can be exempt or deferred, there is a deferred consent for participation in research where an individual is not capable of giving consent. This is typically in an emergency situation, and it's based upon a consideration of the practitioner that participating in research is in the best interests of the patient's health. And then it defers that consent until such a time as the person is actually able to give it properly. The second amendment is an exemption for pre-screening for inclusion in research. And this is something that when we were looking at the necessity and really the proportionality of bringing this, and we talked a lot to people in the health charity field. One of the reasons that this was brought in it's to allow healthcare practitioners to look at patient files and to identify patients who would be most applicable to join a health research study. The processing of the initial inclusion can be done without explicit consent. And one of the reasons this was brought home to us is that it can be quite distressing for somebody to be approached to give consent to be examined for eligibility to join a study, but then to be told that unfortunately the study won't apply in their particular case. So it kind of holds out hope for somebody that there may be a treatment available, but then that hope is taken away. So what this amendment now allows is for processing to carry out that check for eligibility, but with very, very strict safeguards. And of course, before enrolling in the study, the person must give their explicit consent. And then the third one is around what's called retrospective chart review studies, which is part of the work of teaching hospitals and other educational establishments, where once a student is under the control of a healthcare practitioner attached to the particular hospital, medical charts can be used for their studies, and research can be conducted, as long as it is only done on existing data, so that no further patient data is gathered, and it has to be identified as very, very low risk to any of the patients involved. And what's important to note with all of these consent exemptions, and this is really, I think, when we looked at it from the DPC, we took the view that these amendments were justifiable on the grounds of necessity and proportionality. When we look at all the other safeguards that still exist, even though consent may be exempted. So these are the conduct of a data protection impact assessment, called a DPIA in data protection law. So this is required before the study can commence. The access to personal data must be carefully governed. Only authorized persons and properly qualified persons should be allowed to get access to any of the research data. There must be proper measures in place to maintain security and integrity of the data. So that can include IT security measures, but it also includes things like data protection training and making sure that people are actually aware of the importance of handling data properly. And of course, no research study can take place without the prior approval of a research ethics committee. And we're also seeing moves ahead at a national level to bring research ethics committees under a national legislative framework. And finally, the thing that we consider to be most important is transparency, is that none of this can happen unless people are made aware that the processing is taking place, that they know who they can contact if they have questions about what's going on, and that they know what their rights are. So all of this underpins health research, whether or not the explicit consent requirement is in place. And it should also be noted, I suppose, to go back in a circular manner, that while the health research regulations are made under Section 36 of the Data Protection Act, all health researchers are at all times subject to the provisions of the GDPR. And regardless of their compliance with the health research regulations, the DPC has a statutory right. The commissioner has a right to commence an investigation or to conduct any other enforcement actions that we see fit if we have concerns that something is not going as it should in a health research project. So I think we can bring the presentation to a close at this point, and we can take any questions. Thank you very much.
Thanks very much, David. Now we have one last poll as well, which I'm just going to put up. Thanks to everybody for their engagement there. And really the last question is about, do you know more about the role of data protection in your care and treatment following this session? So do you feel better informed now, having spent the last half hour of that looking over the presentation? It's going to leave that up there for maybe about a minute, and we have some great questions. Really appreciate those. Actually, even more coming in there, so that's fantastic. What I'm going to do is just give a few more seconds for the polls. I just want to put the polls up to start our conversation and just let us see how things turned out. I'm really very grateful for the engagement we've had over the polls. And I think our colleagues may be very happy with how the numbers are looking there. Just going to give it 10 more seconds, and we're going to end there after a minute. So yeah, I'm going to end that now, and I'm going to put. Hopefully, you can see the last one there, which shows that people were pretty happy. I think 90% of people agreed that they did know more. And I'm just going to share my screen now in 1 second. Hopefully my technology keeps up as well. I'm going to share my screen with that one. And okay, let me just put up on here just so we can see how our polls actually went. So hopefully on this quite busy screen there, you can see our polls. I guess at the outset, about a third of people agreed that they were confident enough in their role of data protection plays in care and treatment. About half people maybe neutral, and a fifth of people disagreed. Then in the second poll, which I think is probably the more meaty one, what are people really worried about? And I suppose, how secure is my data? So nearly 2/3 of people had that as a concern. About half of people want to find out what happens to their data. I think that's a common challenge for the research community because research takes a long time. People often sign up and consent and then they don't know what happens. Can doctors access, can my data be used for research without my consent? So 40%, 4 out of 10 people interested in that. And really, a couple of other things we will have a look at in there as well. So I might pass over. I'm just going to stop sharing because I'll get confused. I'm going to stop sharing my, I'm going to stop sharing my screen. If I can bear with me 1 second. I have too many screens open. My camera is in the way. So I'd say Shauna has probably rescued me there. So we're just going to go into the questions now. Just going to open those up. Hopefully we'll get to as many of these now as we can. So the first one there is from Eileen. I suppose it's more a comment really. Great that the main stakeholders, which is all of us, are getting to engage. To date, we've had little or no input into health data. So David or Vivienne, I mean, do you want to comment on that, I suppose, on the public discourse, the public contribution, how people have or haven't been involved, and I suppose how that might change maybe in the future?
Just very briefly on that point, and thanks, Eileen, for the comment. I think it's really important that people are given the opportunity to get involved in this conversation, and it's something that, as Vivienne said, we are really keen to do. We're delighted to have done this today with the Irish Cancer Society, and we're very open to talking to other bodies that have a relationship with particular patient sets, to repeat this kind of exercise. Because I think people can feel a little bit at a remove from the conversation that goes on at policy level. And again, we don't set the policy. We're not the lawmakers in this regard, but we do have a role to educate data controllers, and we can't provide the guidance, I suppose, that's most relevant if we don't also engage with the other side, with the patients, so that we know what's worrying people, and what's working and what's not working. So